Hey, what's up, everybody? It's Stephen A. Williams, president and founder of the creditrepairshop.com. And in today's video, we're going to talk about responding to debt collector court summons. And before I get started, I want to ask you to please like this video. This is going to be good content. I know it's going to be able to help you if you have debt collectors coming after you, trying to sue you for your money in court. So like this video. If you haven't subscribed, please subscribe. It'll help us be able to help more people who have this type of situation. In one of my videos, I showed where there was over, I think, 300,000 people that were being sued in just 2 states, and 98% of them were just straight up default judgments where people either came into court and didn't know what to say, or they just didn't even show up to court. And I think that people don't show up mainly is because they're just either afraid, they don't know what they're going to say, they don't know what they're going to do. They think that it's just the end of the road, and that when a debt collector buys the debt, that it's just, there's nothing that they could do. Or they think on the other side, if I don't show up, if I don't respond, nothing's going to happen. And then all of a sudden they end up with a judgment on their record. And we see that notion or that advice that people have given on other YouTube channels, that doesn't work. And then also on the video, just in case you watched my video from earlier in the week on the medical debt, where I had explained, about the Surprise Act, where they can't surprise you with a bill, or if you don't have insurance, they have to detail out all the information. A lot of people were getting confused, thinking that was about getting the information off your credit reports. No, this individual was being taken to court, being sued for money in court. So it's way past, that getting it off the credit report, that's going to be, if you put them on a scale, that's going to be the low-hanging fruit. We're talking about where they could go and get a judgment that would stay on an individual for 20 years, where they could try to collect, garnish, seize bank accounts, all of that stuff for 20 years. Who wants to have that over their head? And but I was able to help that individual because they cannot do that type of billing with insurance or without insurance. There are certain things that need to be disclosed. So if you have medical bills, please go watch that video on my channel also. All right, so let's get into it. The way to beat debt collectors' lawsuits, because this here is the thing that if I get the most emotional messages that I get in my email box, comments in the YouTube chat boxes, or whatever you call it, reply boxes, is about debt collectors suing people. And so what I want to do is I want to help you with what you need to do to be able to beat debt collectors, to put yourself in the best position to be able to beat them, utilizing their own information. See, one of the things that they try to trick you with is they try to say, bring your documents. How are you going to prove your documents against our documents, to be able to prove your case, when it's actually not supposed to be that way? They are trying to prove you owe the debt. That's why they have to take you to court. They can't just go and say you owe the debt. They have to actually go to court. Now they'll try sending you papers and all of that, but if you don't comply with those documents, then the next step with those requests for payment, the next step that they have, the remedy, is to sue you in court. And where a lot of people fall short, even attorneys, is that they try to just push it. Well, people usually don't show up, or even if they show up, they don't know what to say. And then attorneys just try to push people to bankruptcy. A lot of them try to push people to just do bankruptcy or to do a settlement without putting pressure on the third-party debt collection company to make them prove every aspect of their claim. See, they try to let that just fly over everyone's head, that the documents that they're presenting, they just are assumed to be true. I made a video I'm gonna have to get the name of it, but there was a webinar where there was a judge that was in court. You know that does the courts. His court is where he sees debt collectors every day, and he was stating that like 90% of them don't even have the grounds, the basic documentation to even prove their case, but he can't just, be on the side of the consumer. I'm pretty sure that he might ask certain questions, but if the consumer is not engaged and doesn't know what to ask for, then, the judge is just going to rule in favor of the plaintiff, which is the debt collection company. And so he was like, if they could just know the basics, and I've even read this in consumer articles, consumer books, that if you just really know the basics, that you would put yourself in a better position to either win your case or push the debt collector to try to offer you a excellent settlement on your case, and you can make that decision on how you would like to move forward. But the power would be in your hands, not in the hands of the debt collector. So now let's look at it here. When you get a when you get, put this in red here. When you get, the first thing you're going to get, if you're going to get sued, you're going to get a summons, and you need to respond to that summons. If you don't respond to that summons, you're already putting yourself in a bad position, because they're asking you, those are allegations about you and in relationship to the debt. But a lot of people don't know how to respond. So what I tell people to do, and this is just the basic, because every summons is going to have something different to it. For a while, there was a lot of templated ones where they were just sending the same thing, just changing the names and stuff like that on there, and the account information and the amounts. But I think that we had beat so many of them that they started saying, hey, you can't just make a template. You need to really put something together that we believe that will show that this individual has to pay us this debt. And I've seen those adjustments with debt collectors where they were just blasting out templated court summons complaints, and and then all of a sudden they made that flip because they were losing. It was just for the defendant, dismiss. All of that stuff was happening. So first thing you want to do is you want to make them prove that relationship, that contract. You hear that said a lot on YouTube or on other platforms about what's the contract relationship. They're going to have a relationship where they purchase a debt, but you want them to go into more detail, not just to have something on the surface to show the relationship between you and them. And they might even try to throw in that you were non-responsive in the court summons, that they tried to work it out with you. They tried to do all of these different things. And this here is your response. You have no reason to respond to them and to communicate with them. You made requests if you follow my other videos, you've already made the request before it even got to court, or even if it didn't, you still can make the request that they need to, because you're doing a response before the court hearing. So you want them to show that relationship with the contract. Of course, they're going to just send statements and stuff like that, and some other things that I'm going to show you in a minute what they're going to try to send. And I'm going to show you how to break that stuff apart so you can win. Next thing is a true accounting statement. They can't just walk up to you and say, okay, you owe us $5,000. Just imagine you walking down the street, someone said, you owe me $5,000. I got the last two statements that you had from your credit card account, and it says that you owe, $7,000. And I got two statements that, and when I look at those statements, I would look at them and be like, well, number one, I don't know who you are. You need to prove this. Number two, these two statements, the charges that are on here do not equal $7,000. So you want a true accounting statement, not just the last couple statements. You want everything, and that gets into right here, but we'll talk about that in a second. Next thing is you want a full account number. They only provide the last four. You have a right to know the full account number. You maybe had accounts, multiple accounts with that creditor. So you want to have this. What you're doing is you're, number one, making it, giving the impression that you're not trying to run from anything. You're trying to get data so you can make an educated decision. The same thing that the debt collection company did is that they gave documentation to the court saying this is the data that we have and we want you to rule on this data. Well, you're just turning around saying, well, the data that they presented to you is not complete, and I'm requesting to get more information on that data. Now, they won't be able to get it. The next thing which goes into here is that you want them to, and these two actually go together, is that you want them to, for the true account statements, is they're going to need to show your signature or PIN code receipts for all charges, interest, charges, fees, rewards, and payments that you've made, and some other things. I just didn't want to make it so long, and even rewards. What you want to do is you want to compare everything. If you were to call up the original creditor, let's just say your account is in good standing, and or it's in bad standing and they haven't sold it yet. If you were to make a phone call and said, I want you to give me all of this stuff, they would have it mailed out to you within a week. And you would be able to review it and determine if what they're claiming is right. And that's with the original creditor. When the debt collection company buys a debt, they assume all responsibilities for the accuracies, the inaccuracies, everything. That means that they must have every piece of information to prove the claimed amount. Because that's what it's all, when it all comes down to it, for that $7,000 that they're trying to get from you, they need to have all of this information to prove that amount. They need to have all of that information. Doesn't that make sense? Shake your head if that makes sense to you. Shake your head. Say, yes, Steve, that makes sense. Say, yes, Steve, it really makes sense. If I make them go ahead and get all of this, I actually feel a little bit more comfortable about going into court, because all I'm doing is asking questions for you to bring me some information. Or if you're giving them this before you even go to court, and they may just back out because they're going to be like, wait, you're asking for information that we didn't expect you to ask for. But wait, it even gets better. It even gets better. So now this is the basic. I call this the basic defense because, like I said earlier, they've made some changes. They've made some adjustments. And so you're going to have to read through it and make adjustments based on the information that they send to you. Some of them are utilizing more specialized debt collection firms that are in, everyone's areas. There's always some debt collector that specializes, or some attorney in your area that specializes in collecting debt. Trust me, the debt collection companies do not really specialize in collecting debt. They specialized in being able to go out there and get and collect debt with people who didn't know their rights and also who didn't show up to court. But when people started challenging, then they were like, hey, we need to hire someone in that area that's going to take this up a notch. But don't worry, we still win against them, and I'm going to show you how you win against them. But the thing that you have to do is you have to read it. You have to see what additional information they put in there to try to make it look like they have all of the records to prove that you owe the debt. So now, in your defense, with every court summons response, you are required to put an affirmative defense. Like, what is your comeback defense against them? And this is where a lot of people get messed up. This is where they mess it up. And you have to be very careful, because if you get into making it look like you have documents that they didn't present when they initiated the court summons, they're going to try to flip it around and say that you need to produce those documents. So, like, you're going to say, you need to produce these documents to say that you don't owe this amount of debt, when you should have made your response show that, based off the documentation that you presented, does not show that I owe the $7,000. It shows a couple of statements, but that does not show that I owe the $7,000. And you put it back in their court to bring those documents. You have to be very careful. It's very subtle. It's very subtle, but we've actually helped clients win. One that came to mind was a gentleman who was being sued by a truck leasing company for $28,000. And we got that dismissed by putting that exact information in there, where we made them understand that he is not trying to say he has documentation to get to them. He's going off of the documentation that you presented, Mr. Debt Collector or Miss Debt Collector. So again, we're reiterating in our defense contract. Also, we're talking about privacy. Show me the documentation that even allows you to have access to my private information. If you say you got it from the original creditor makes me sign privacy statements all the time. They send emails or they send texts. They put it in your bill saying that the privacy information has been updated. And I think that they're trying to sneak that in there if they end up selling the debt, that your privacy with them moves over to the privacy with the debt collector. But what I've seen, at least up to now, things could change. The courts do not like that. They want everyone's private information, when it's transferred, have some sort of documentation that notifies the individual that their information has been transferred from one company to another. The next one is the audited account of the claimed amount. We got into that earlier, but using their own documentation, we reiterated and restated in that defense to get them to get that audited information. They're going to try to send you a statement. You never know what they're going to try to put in there, but you want them to get that information. Next thing is they're going to probably try to say that we have your information and that we do have a contract because we have a portfolio that we purchased. They never have your name specifically on that portfolio. As a matter of fact, if they were to try to do that, they would have to put everyone's name on that portfolio sale document. They do not have it on there. I'm just going to leave it at that. I don't think I even have to go any further. The next thing is the accuracy of the portfolio. If you read the portfolio contracts, if you read them, that's with your court summons, they never state that it is 100% accurate. And you might be saying, well, what about my information being 100%? No, that does not matter. That's like saying, you have a bucket of water and only put a little bit of poison in there. Are you going to drink the water with a little bit of poison? No. If the portfolio is not 100% accurate, that, in my opinion, and the way that we've been challenging it, is that means that the whole portfolio is not accurate. It does not matter about yours, doesn't matter about someone else's. What we're drilling down on is what they said in that portfolio signed by the original creditor sale document, that it says in there, it always says it, that the debt collector assumes the responsibility of everything, accurate information, inaccurate, everything. There's some other stuff that they stayed in there. But what it's doing is that the original creditor is trying to take off any issues that may come up in the future on the way that debt collector tries to collect on that portfolio. The next thing that you need to pay attention to, and there's other things, I'm just talking about the basics for this video, just so we don't have to have one of my longer videos, is that the 1099-C cancellation of debt. We would see this a lot with the original creditors canceling out debt. Now, the thing about it is that it's kind of tricky because they don't actually say it in their court summons. This is information that you would have to go out and get that information. And I tell my clients to do it one of two, well, do it both ways, is to call the original creditor or write the original creditor and just specifically ask them that they cancel the debt. The word cancel debt is a legal term, because if you cancel debt, that means that it could be reported to the IRS as a 1099-C cancellation of debt, which makes you not have to pay the debt because you're going to have that put as income, and that's going to have to be reported with the IRS. So if the debt collector is trying to collect and the IRS is collecting, that's double jeopardy. So you want to make sure that they let you know in writing that they didn't, but you're also making that request to the debt collector or in your response to the summons. Now, this will be a document that you would have to produce, because they're going to say, what do you produce a document that states about a 1099-C. If you look on your credit reports at the bottom in the comments, and you need to get one that's a paid monitoring service, you won't see this in those free monitoring services. In the comments section, it will show you if it was canceled. That would be your documentation that you would bring to the table. Because remember, they're going to ask you, produce documentation to state your claim. And that would be the document that you would need to be able to state your claim and say, hey, this was done in a 1099-C. I've seen this happen a lot of times where when that document was produced, and all you're doing is just making a copy of your credit reports and you're stating it on there, when those debt collection lawyers that are collecting it for someone else, I've even seen this happen with the original creditor. They will send that debt back to the original creditor, or they would dismiss the case and tell the debt collection company who hired them that they don't want to be involved. On my website, you will see the biggest one that we were able to get, to be able to get the document where it was canceled, was a Citibank card for $36,000 for a client, where that was actually done by using that process. And it wasn't even in court. That process was just utilized back and forth with the debt collection attorney that was hired by the original creditor on that one. So there's always opportunities to be able to beat debt collectors. All we have to do is open our mind to the possibilities and just look at the documentation that you have in front of you and figure out a way to be able to respond to them and put yourself in the best position. If you need help with third-party debt collection lawsuits or original creditor lawsuits, we can work with you on both of those to get you in the best position to either win or to have a very good settlement in your behalf. Or if you just need to get a settlement so you're able to move forward in your life, we can help you with that situation. Links are below this video. If you need help with your credit, please visit us at thecreditrepairshop.com. Watch the video, what makes us different, so you can see my 8-point validation process, my 2-phase settlement process. That's the way that we repair credit. If you need your credit reports and scores, go to the website your3scores.com. You can get your TransUnion, Equifax, Experian credit reports and all 3 scores. If you have debt collectors coming after you, remember I always have my 3-pack of letters: the statute of limitations, cease and desist collection activities letter, and the debt validation letter. Thank you for your time. Please subscribe to the channel. Please post your questions.